Hello and good afternoon, and welcome to our WA Q&A. You decide who decides how to make an enduring power of attorney for financial decisions. I'm Brett Osmond, the editor of Compass. Compass.info is Australia's national information hub on tackling elder abuse, raising awareness of abuse in all its forms, and helping people find information and services so they can respond and reduce or prevent abuse from happening in their lives. I'm coming to you today from Sydney on Gadigal land, and I'd like to pay my respects to elders past and present, and to welcome you all this afternoon, and in particular to welcome Shawnee van Poeteren from Advocare, who is joining us today from Perth to talk about this really important topic. So thank you very much, Shawnee, for joining me.
Thanks, Brett, for having me. Looking forward to the conversation.
Now, just a little bit of housekeeping. While everyone comes online, we're going today to use the chat to answer your questions. So I've just put a little welcome message in there. So type your questions in there, and Shawnee and I will get to them. It really is a session today to respond to the questions you would like us to cover. But Shawnee, in advance of today's conversation, has prepared a really good list. So I'm going to start actually, Shawnee, with your first question, which is a really good one because we at Compass get this question posed to us, more often than you might think. What is the difference between a will, an enduring power of attorney, an enduring guardian, and an advance care directive?
Okay, so first off, Brett, all of them are legal documents. An enduring power of attorney gives a person the ability to nominate someone to make legal, financial, and property decisions on their behalf. An enduring power of guardianship is to make decisions related to lifestyle, treatment, and healthcare. A
Mhm.
will is something that people put in place to make sure that their assets and property are distributed as they would like them to be after they pass away. And an advanced health directive is a document, a legal document that outlines your treatment wishes if you have no longer the capacity to do so. So, if it's a major car accident, you're in a coma, you have your explicit um, wishes outlined there, and health professionals, if they know of the document, have to abide by what you've put in there for things you do want and things you actually don't want to happen to you.
Wonderful. Thank you, Shawnee. Welcome to you, Catherine, and from Geraldton. Lovely to have you with us this afternoon. Now, I'm going to give a few plugs for Compass this afternoon. Compass.info. It's a free resource to all older people and younger people, all Australians. And there is a terrific section called Future Planning, where you'll find information about wills, advanced care directives, and a very comprehensive section on enduring powers of attorney, which we will reference today a few times. So, can I put it to you then? We're going to focus on an enduring power of attorney. Why plan for future financial decisions? Why is it important for people to think about this document?
Most people want to exercise choice and control over their decision making long after they no longer have the capacity to do so. So it's important to think about those things and who the best person might be if you are no longer able to make those financial and property decisions. Super important. The word power in there isn't there for no reason. It is a powerful document. And so you have a voice after you no longer have capacity, if you choose the right person to act in your position, be your substitute decision maker.
Okay, great. And welcome to everyone else. Welcome to Yvonne and to Nina and Andrea. Thank you very much for joining us today. By all means, get your questions across to us. Um, what are the easiest, cheapest ways to create an enduring power of attorney document in Western Australia?
So in WA, if you go onto the website for the Office of the Public Advocate, they have a free kit for enduring powers of attorney and enduring power of guardianship. They're pretty simple documents. The kit gives you instructions to follow and it is quite succinct. It's free to do that. You don't have to register it anywhere if you don't wish. But being a legal document, there is recommendation that you do seek some legal advice, particularly if you have specific matters you need to consider or there's a complicated issue that you want to put in there. Some people put in clauses. So anything out of the ordinary, it's recommended that you seek legal advice. That obviously comes with a cost, but if
Mm.
you just want to fill it out yourself, have it witnessed appropriately, it's a free document.
Right, yeah. It is that process of creating an enduring power of attorney. I know a number of people I've spoken to think it's a templated document, everyone's the same, but that's not true, is it? You can really customize it to suit your needs and put instructions, limitations um, for your attorneys. And so it's something that people should think long and hard about, isn't it? Because it really is a guide for your attorneys to know what decisions you want made on your behalf or made in support within a supported decision making sort of setup, isn't it?
Correct. Some people might just want someone to act on their behalf to sell a property, but nothing else to do with their finances. So there are clauses, there are conditions you can put on there, and it's different for everyone.
Mm.
Someone might need or would like someone to take over to do everything, and that's okay as well. So it's really important that people consider what is best for them because it's different for every person.
Now, I guess one of the biggest decisions when you're creating this document, it's a legal document, is choosing the right attorney. So
Yeah.
who makes a good attorney? Often people choose their partners or their adult children. They seem to be the default choices or a close friend. But what characteristics make for a good attorney?
Before I get into that, Brett, I just really want to say, yes, you're right. People do choose their spouse or their adult children, but I would like people to know that they have choices other than those people because
Absolutely.
they may not be the most appropriate people. We
Mhm.
love our partners, we love our adult children, but they still might not be the most appropriate person. So I would advise people to have a look at who they trust, who manages their money well, who respects them, listens to them, who they know if they didn't have the ability to make their own decisions, that person would act on the wishes and preferences of them, not what they thought was best. And a lot of people do that because they think they're doing the right thing. It's not necessarily the right thing for the other person that wouldn't necessarily make their own decisions. Someone who manages their money well, someone who the person doesn't have to be living in the same state or the same region, but someone that is accessible.
Mhm.
More importantly, someone that knows the responsibilities of what the appointment holds and is willing and able to do that.
Mm.
So there's lots of things. You just think about what's important to you, and you know look at some of those people that you might know that you would know wholeheartedly would do what you would like them to do should they no longer have the capacity to make their own decisions. Family of choice, so it doesn't need to be a
Mm.
spouse or a child. It can be anyone that you know and trust that you consider a trustworthy person.
Yeah. Now, that's actually just a nice reminder for me to probably expand a little on the reason why we've called today's Q&A You Decide Who Decides. It comes from a terrific publication. A new edition of You Decide Who Decides has been published just this month, and it is out from the Australian Guardianship and Administration Council and is available on the Compass website. You will all be emailed a link to it along with an introductory video. If not tomorrow, the recording will be edited and sent out on Monday. It's got some really good tips as well, doesn't it, on who makes a good attorney and things that possibly might present as red flags, such as people with financial difficulties, maybe substance or abuse or gambling issues. And it recommends a number of other things for people to consider. Now, one that I considered when I created mine was putting in place a substitute decision attorney. So my partner is the first port of call, but then it defaults to my niece, who is much younger than me. And so, is there advantages in people putting a substitute attorney in there and for having someone much younger than them?
Absolutely, there is. That was another thing to consider. I'm glad you brought it up. Um, People sometimes appoint someone that is a bit older. You realistically need to look at, are you going to, is that person going to outlive you, or you are going to outlive that person? A substitute decision maker makes it easier if the original person you appointed is no longer able or willing to fulfill their duties. You don't then need to go through the rigmarole of creating another document, or if you've lost capacity, it won't then necessarily need to go to the State Administrative Tribunal.
Yeah, yeah. So good to have some backups in there because
Absolutely.
this document could be in place for a long time,
Mhm.
couldn't it? And, an attorney might actually want to step down from the position or step away from it. That can happen as well, can't it?
Absolutely. An attorney that you appoint can resign at any particular time. They will need to let you know, they will need to do that in writing, they'll need to return any documents that you have provided, legal documents, and then it's up to you what you do next if you have the capacity to make a decision at that point.
Yeah.
But just because you've said yes to being an attorney doesn't mean that that is forever and a day if you decide you can no longer take the responsibilities of that position.
Now, legally, you've mentioned it can be number of other people, not necessarily your partner or your adult children.
Yeah.
As far as I'm aware, the law is as long as you are over 18, you're an adult and have capacity,
Yes.
then you are a possible candidate. If people don't have somebody that they know, they trust enough to give this very important power to, what other options do they have?
One option they have is not to make one at all.
Right.
That would be safer than just appointing someone because you think you need to. But if you do really want to appoint an attorney and you haven't got someone known and trusted, there are agencies that will do so, and there are certain professionals that will do so. I believe that accountants can, lawyers can. WA, if you're talking about a government agency, the public trustee for a fee can administer your wishes and your finances should you appoint them to be your enduring power of attorney.
Right. Now, as I mentioned earlier, it's a document that, people often, I've made mine already. I'm in my 50s. It might not kick in ever, but it could
Yeah,
actually kick in a quite a while. And so, do you recommend people review their enduring power of a document just to see if everything is still hunky dory?
absolutely. It should never be a document that you set and forget because
Yeah.
things change and people that you've appointed change as well. Um, your opinion of people and what you might like changes. I made mine by 18 months ago. I'm going to change certain things in mine because I've looked at things differently. And they're not drastic changes, but I think it's really important that people remember that these documents, if they've created them, exist and to review that because it safeguards them. Um, yeah, I would recommend that people do that. And I think the recommendation from the public of the um, the public advocate is every 1 to 2 years. Some people say leave it up to 5 years. We never know when something's going to happen and incapacitate us. So yeah, if you reviewing that every couple of years would probably be best practice.
Right. Yeah. Good advice. Now, in Western Australia, can you appoint more than one attorney?
You can up to two.
Oh, up to
Um,
two.
Up
Right.
to two. So many people just appoint a sole person. Other people can appoint two people as joint decision makers. That means that both people need to make the decisions together. They can't do it separately, but you do have an option of doing joint and several.
Mhm.
So you'll have two people making decisions, but they can actually, one of them can do them independent of others. A lot of people make that decision to have joint and several, particularly if someone lives overseas and it's harder for that person to
Mhm.
work with the other jointly appointed attorney. However, if you're jointly appointing people, you really need to look at the dynamics of that arrangement. Do these
Yes.
people cooperate? Um, do you think they're going to be on the same page? Is it going to cause more trouble than not having these two people making decisions for you? A lot of people do that, particularly the joint option, to safeguard themselves, thinking, surely two people have to be on the same page so that those decisions will be, in alignment with my
Some checks and
workplace.
balances in there. Mm.
Absolutely. But, it really depends on who you're appointing at the end of the day, like we've already said.
Yeah. Now, if you have appointed two attorneys and they are unable to agree,
Mhm.
what happens next? I'm assuming there might be some mediation type services available initially, or do you have to go to the Western Australian Civil and Tribunal? Um,
If the person that's appointed these two attorneys still has capacity, it's up to them what they want to do. It would to be making a new enduring power of attorney and working out, what the best process is there. If that person has lost capacity,
mhm.
there's an issue with decision making. Then yes, it would go to the state administrative tribunal for further discussion and reappointment.
Yeah. Now we'll get to capacity in a minute, but it's probably a really good time to mention that in Australia, the enduring power of attorney document is there are different rules depending on which jurisdiction, which state and territory you live, and they're actually called different things. And so in Western Australia, I think you're quite similar to New South Wales in requiring an enduring guardian. But in the Northern Territory, it's called an advanced personal plan, and you appoint decision makers. In some states, an enduring power of attorney covers both financial and health and lifestyle decisions. So it is important for you to be very aware of what rules apply in the state in which you live. However, are there issues, say, if somebody in Western Australia has created an enduring power of attorney and then has relocated to live in South Australia or in the Northern Territory or somewhere else? Does their Western Australian enduring power of attorney still hold legally, or should they make a new one?
It still does hold legally. So if someone was living in WA, their property assets remain in WA and they've moved to Victoria, then the enduring power of attorney that has been made in WA is the one that should be enacted.
Mhm.
Similarly, if a person has moved from a different state and territory to WA, but their property assets remain in, say, New South Wales, then it would be advisable to contact the government bodies in New South Wales to see what their legislation is there, because it is different. But if you move from WA to somewhere else, it is still a legal document that can be enacted.
Right. Now, I've got a question here from Andrea, a really good one. We mentioned that you can put specific information into your enduring power of attorney, but Andrea asks, where do you put that piece of information? Because there are only two lines in the document for you to supposedly add detail. Is there a supplement paper, or do you just literally write instructions on a separate piece of paper and kind of staple it and witness it? Um,
For that, Andrea, I would suggest if you're doing if you're making specific instructions, that you see a lawyer and they will guide you through the process, taking your point that the actual document that you would get off the government website is quite short-lived.
hmm.
I can't answer that from a legal standpoint, but this is why legal opinion advice is recommended, to make sure that anything that you write there, and if there's a tendency that it's created, so it's recognised by law.
Yeah, yeah. And one of the things we've had a few Q&As and some of the comments and conversations have led us to say it is great to put instructions, but also not to be probably too specific, because it could have inadvertent limitations. And, life has a funny way of going in directions that are unforeseen. So, very important, probably, there to seek independent legal advice, so that they can check that the instructions you're coming up with aren't going to create future problems. Um, Now, a question we often get is, okay, both you and I have created our enduring power of attorney, but when does it kick in? When does it become active?
Well, you've got two options for enduring power of attorney. You can appoint someone immediately, or in the event that you lose legal decision making capacity. So, with enduring power of guardianship, you don't have that option. It is only when you lose capacity. But for an enduring power of attorney, there is two options. Most people I know will choose when I lose capacity, and that's because they want to retain, that control for as long as they can. But there's certain circumstances that people will say immediately. They might only need a little bit of support, but it's helpful for them to enact it now rather than after they lose capacity.
Wonderful. Now, we'll come to capacity in a second because it's a very interesting subject in and of itself, and is obviously very key to this document. But we'll answer two questions here. One from Nina. Is there a way of allowing three siblings to share equally in, being an attorney for an enduring power of attorney in Western Australia? And I guess the answer is no. You can't have
No,
three. Yeah.
no, up to two. Someone can be involved informally, but legally, there can only be two people appointed in WA.
Now, Catherine asks a good question. I'm not sure that I can answer it, but we've got a very extensive enduring powers of attorney section on Compass, compass.info. And within that, you can click on Western Australia, and it has lots of information there, including a really helpful checklist for you to go through and all the forms required. Catherine says the Office of the Public Advocate um, say that they specifically won't give out a Word version of the EPA in their kit. Is there a Word template online for WA that you recommend? Probably not, I would imagine. Is there?
Um, I, as we go, there's
We'll look
probably
it
not
up.
if that's what they're saying,
No.
but I think that that's something that I can feed back. We, Advocare, who I work for, work closely with the Office of the Public Advocate. So that's problematic if they don't give that option, because not everyone will be able to access that electronically. So
Yeah.
I can follow that up if there's nothing that I can find online.
And I might check too while we're chatting. I can click on
Yeah.
the section on Compass myself. Alan asked, what are your thoughts on appointment of a corporate attorney? Potentially introducing more than two individuals. Well, you can't introduce more than two, but the idea of a corporate attorney, so people appointing their lawyer, an accountant, someone. What are your thoughts on the things people should be thinking about, if they want to go down that path?
Oh, look, I would go back to the name of the document. And while we're here today, you decide who decides. It is
Yeah.
better sometimes for someone to not involve people that they know. Some people are, even with their loved ones, are quite, what word? Not secretive, are quite, um, they want to retain their personal information and not share that with other people. So for, for people that, for people that want that anonymity or someone professionally to support them, I think that might be the best option. I personally wouldn't, but that is my personal preference. But I know other people do with great success. So it is individual choice.
Right. Yes. Individual choice.
Yeah.
Absolutely. I think the thing to notice, though, if you do want to go down the corporate path, there is a fee associated with that. And so, otherwise, choosing a friend, your partner, or your adult children, unless you make specific provisions, it's an unpaid role.
Yes.
And so, it has been designed that way. Um, Now, I just want to, before we go to any more questions, of which we will return to, capacity you've mentioned a few times. And it's obvious that for many people, including myself, that's when my enduring power of attorney is going to kick in when I lose capacity. First of all, what is capacity and who decides if you've lost it?
So, capacity is a legal concept referring to a person's ability to make specific decisions.
Mhm.
Um, Sorry, Brett, what was your other
It
question?
was, what is capacity? I mean, I
Yeah,
understood it as your ability, say, in the instance of this document, is to understand what an enduring power of attorney is,
yes,
for you to be able to weigh up alternatives, retain information, and
correct.
then be able to communicate your decisions, even if it's non-verbally. And so if you're not able to do those things, then I guess it's it's a legal test informed by medicine, by medical practitioners who might say you don't have capacity, but it's not an absolute thing, is it?
It absolutely is not, and you're right. It is that ability to, what decision am I making and why am I making it? Um, do I know the consequences of the decision that I'm making if I do make it?
Yeah.
And capacity is fluid and it fluctuates for all of us. And that's because of illness, it's because of disease progression, incapacitation for a certain period of time. So it's it's a really hard thing to measure, even for medical health professionals. Mostly, what we hear is people will go to their GP, they will see a psychiatrist, a neuropsychologist. They use all sorts of different tools to test for capacity, but testing for capacity in one realm doesn't really necessarily mean that you can make a judgment about someone's capacity to make another sort of decision. So you might not be able to create a will and do something that's a legal document, but you'll be able to pay your everyday bills.
Yeah.
It really depends. And we see that fluctuate with people with quite significant mental health issues, and they might be incapacitated for a period of time, hospitalised, they don't have the ability to make decisions, then they have the treatment, medication, and then they regain the capacity again. Similarly, with people with cognitive impairment, just because they have a diagnosis doesn't mean that they're, you know, no longer able to make their decision. It might get to that point, but it is fluid and it fluctuates quite often.
Yeah, yeah, really good answer. Thank you. Capacity, we've just published an article on urinary tract infections, we know, which can often lead to dehydration and, can be one of the causes, and delirium could be a symptom. And so in that moment, you might not have capacity, but your capacity could return once you're over your illness. And you might have capacity, as you say, to make those simple decisions, but might be not more complex financial ones. And so it is something, I guess, Andrea, who's asking this question, it is a process. It's going to be different for everybody, but they're the sort of general parameters around it. We have a terrific article on Compass called Having Capacity, and there is a short video in which you can also watch, which outlines a little bit more detail around it. But it leads me to ask you about, before we go to some more questions, about this idea then that, the principal might be able to make some decisions independently but not be able to make others. So the idea then of supported decision making is a really big factor now, isn't it? And increasingly becoming mandated through legislation. But it underpins the sort of approach attorneys need to take, doesn't it?
Absolutely, it does. Supported decision making is supporting a person to still have a voice. However, they need support to raise their concerns and express their wishes and their preferences. It is now being legislated into the new Aged Care Act 2024
Mhm.
around aged care providers' responsibilities of supporting an older person to make those decisions. So it's across lots of different realms, lots of different industries, and it's around giving that person time and space to understand those important decisions they're going to make it. And you can do that in varied ways.
Yeah, yeah, yeah. We've got a great article as well, another plug on supported decision making, and another one also on, if someone receives a diagnosis of dementia, it doesn't automatically mean they've lost decision making capacity. And supported decision making is going to be increasingly important for people who do have cognitive impairment because cognitive impairment progresses. It's a progressive condition. And so that support will change, I imagine, through the course of that person's life. So some great information and resources there. Now I'm just going to go to Alan's question. What are your thoughts on the appointment of, we've done that, a corporate attorney. Can an attorney, so it's a follow-up question, can an attorney be a company, a PTY Ltd company?
And another legal question, I would
Yeah.
think, something that I can't answer. I've not known that to
Oh,
be the case,
same.
but yeah, it would be a legal question, that one.
Yeah. Now, we've mentioned, it's important to have you don't have to register your enduring power of attorney in Western Australia, but you do have to register, don't you, with the Land Titles Office if you're going to be transacting in property.
You don't have to, but it's
Right.
recommended that you
Right.
do. If
Okay.
there's property involved, if you're using the will kit, and a lawyer would tell you this anyway, but the will kit from the Office of the Public Advocate comes with two copies. So if you are going to lodge it with Landgate and there's property involved, it has
Yep.
to be one of the original copies. You have to do so within 3 months of making your enduring power of attorney.
Yep.
And that just makes it easier should you lose capacity, that person can um, act on your behalf without having to go through, filling out a stat deck or going back to the state administrative tribunal. It's
Right.
just, again, making the process easier for yourself and the attorney should you lose capacity.
Yeah, yeah, yeah. Okay, so Andrea's asked, can you please talk to the lodging of your enduring power of attorney with Landgate? The fees, I think, best to have a look on the website.
Yeah.
What fees apply, and you can do that on their website or the Compass website. But how does lodging you don't have to, but say you do lodge your enduring power of attorney, how does this help versus not lodging it? Are there
Um,
advantages?
there are advantages, as I spoke to just a moment
Yep,
ago. It
yep,
just makes it easier if there's property involved. If you don't have any property involved in your enduring power of attorney, obviously it's not applicable. It just makes it easier should that person lose capacity and a property needs to be sold, that person that's appointed can do it seamlessly rather than go through the checks and balances that they would need to ascertain that this person has lost capacity, the stat deck that has to be witnessed, all of that. So there's a lot of people that have enduring powers of attorney that haven't gone through that step.
yeah,
It it's really personal preference. I
yeah.
think before the Q&A, I had a look online, and I think to lodge it with Landgate, there is a fee of about $216.
Wonderful. Well, thank you. That's very helpful. Now, are there any risks in making an enduring power of attorney?
The biggest risk that there is who you appoint.
Yeah.
That's what I would consider the biggest risk, and whether that be someone personal or some professional. It, left in the wrong hands, it has been used as a tool for financial abuse, unfortunately. So I would consider that to be someone's biggest risk if they're making an enduring power of attorney. There are things that you can do to safeguard yourself, as in, really putting a lot of thought into who that person or those people are. And if you think you've appointed someone that isn't doing the right thing, then there are options to cancel, revoke that appointment. But yeah, for me personally, and working at Advocare and supporting people in WA on the WA Elder Abuse Helpline, the misuse of enduring powers of attorney and the financial abuse is something that we do hear
Mhm.
quite often.
Yeah. So once again, I guess really imperative you choose the right
Yeah.
person, and if you can, put some oversight measures in place that can't hurt. But what happens to somebody? What would happen to me in Western Australia if I lost capacity and didn't have an enduring power of attorney in place? What happens? Who's going to make my financial decisions if I can't make them?
It would be a concerned party that would go to the State Administrative Tribunal.
Mhm.
A capacity assessment would be conducted, and a determination would be what appointments were required for your safeguarding going forward. Um, when that happens through the State Administrative Tribunal, they do look at people that are closely connected to the person that has lost capacity. So if there is a family member, a friend, someone that has a genuine interest in the welfare of the person that's lost capacity and is willing and able to take that appointment, they will look at those people before applying to the state for administration,
Mhm.
because you know, it's a government organisation. They're not going to do. They're only going to do that as a last resort. Put it that way. So
Okay.
it that's the only way it can be done. After you lose capacity, it has to go through to the state administrative tribunal.
Yeah, yeah. Okay, thank you. Now, are there things you can do to protect yourself from the misuse and abuse of your enduring power of attorney? Obviously, try and choose the right person, but things change, don't they? I mean, you could
Of course.
appoint somebody that you trust, but several decades pass, their life situation changes, and they've gone from someone who was ethical and honest to maybe someone who, might be behaving in a slightly different way. So, are there things you can do to protect yourself, or what happens if abuse is suspected as well?
If abuse is um, sorry, if abuse is occurring, or you think that something is happening for you and you have capacity, the first thing I would consider is if you feel comfortable enough to call that person out and have
Mhm.
that conversation.
Yep.
Sometimes, and people might think that this is an interesting thing to say, but sometimes abuse and financial abuse happens unintentionally. People don't understand what they're doing is abuse. But if it gets to the point where a person wants to call it out, the situation doesn't change, the best way to safeguard yourself is to revoke, is to cancel the appointment. And it's quite a simple process to do.
Yep.
But I would suggest that if a situation doesn't change after you've tried to address it, that the best way to safeguard yourself while you have capacity is to revoke the decision that you've made or the person that you've made.
Hmm. Now, if you've lost capacity
Yes.
and abuse is occurring, what are the likely scenarios there? Does
With
someone
the
have to report? Does someone have to detect or notice? I mean, there could be another family member or a neighbor or a close friend who suspects abuse is taking place. Um, do they have the opportunity to go to the tribunal? Is that their first port of call?
absolutely the same step as I spoke to just before. It would be only at that point if you've lost capacity to go to the state administrative tribunal. And that's what happens quite often. That's how it's a community member. It might be some sort of community provider, aged care provider, a family member, a friend that will go to the state administrative tribunal or ring the Office of the Public Advocate and say, look, I have serious concerns. The Office of the Public Advocate can do a community welfare check, but unfortunately, a lot of people, once they've lost capacity, um, if they have been socially isolated and abuse is occurring and they don't have a wider support network, the abuse can go undetected for a
Undetected.
while or forever. Unfortunately, that's just the reality of the situation.
Mm, mm. Now, I want to talk to you about two phenomenons that we hear about. They're being talked about in the media, and we hear about them in comments people reach out to Compass with. One is inheritance impatience as being a motivator, which is really just a euphemism for stealing.
Yeah.
But it is something that people are familiar with, that term. And I will reference the Australian research that was done and released in 2020. It was a national prevalence study done on elder abuse in Australia, which identified that 1 in 6 older Australians in the community, that's people 65 and older living in the community, was experiencing abuse on an annual basis. And that psychological and financial abuse were the two leading forms of abuse, and that adult children were often perpetrators of this abuse. So, what's behind inheritance impatience? And how does it manifest? What does it look like?
Put simply, it is an adult child's feeling of entitlement.
Right.
This is, what is theirs is mine. It's going to be mine one day, but I can't wait. I want it now. So, yeah, outright stealing, that manipulation and coercion that goes with that.
Mhm.
It's rife. It's bigger than people think it is. But it is that sense of entitlement, Brett, that people go, well, this is, and it's really not yours. Just because your mum, your dad, your grandfather have something, you're not automatically entitled to that unless someone is freely giving to you
Yeah.
from their free will because that's their decision. Well, that's fantastic. But if you are coercing, if you're manipulating, if you're doing everything in your power to get your hands on property, assets, money before it's being gifted to you, that's a form of financial abuse, and it happens oh so often.
Yeah, yeah. There's another term too that I've heard just recently called inheritance maintenance, which I guess really could manifest as neglect, where an adult child is wanting to preserve their inheritance, so therefore not spending the appropriate amount of money on possibly care, food, clothing, and other support services. So that's something that have you ever come across that form of financial abuse?
I have. I've never heard it termed like that. So
Right.
I've learned something today. Yes, absolutely. The amount of times we've heard, like, I've asked mum and dad not to do this because they're, chewing into my inheritance, or I'm going to, if they were the ones that are in control of the money, they will, really filter what happens. And it ends up being that the older person in these circumstances they go without necessary, medication and, social engagement and medical treatment, which
Hmm.
is neglect in itself.
Yeah,
It
yeah.
does happen, unfortunately.
Now, if any of this is triggering for you or you're aware of abuse, Compass is a terrific resource where you can find services and information. We have a great service directory with over 500 organizations. You can filter by state, and there are elder abuse specialists, helplines. Advocare is one of the leading organizations on Compass. And also, there is the National Elder Abuse Helpline on 1-800 353 374. Look, we don't want to scare people, but it's obviously something that people do need to consider and to be aware of. And obviously, there are, options that people have. Moving on from that and just sort of coming back to, you've detected abuse, you might have capacity, you've revoked your enduring power of attorney. In practice, what does that mean? Like, what do you have to do? Do you have to tell people? Do you have to notify people? Do you tear up the existing documents? Yeah, what's the best way to go around about that process, I should say?
Yeah. Please don't tear up your legal documents.
Don't tear it up. Okay.
Please don't tear them up. The best thing to do is to strike through the document, date it, sign it, get a witness to sign it as well. Um, you can do all that and tell the people or the places that you've put your enduring power of attorney in the first place. Really important step is you must tell the person that you've appointed that you've revoked them, because without that step, it's not been revoked
Right.
correctly.
Okay.
So making sure that you get everything back from your enduring power of attorney, you've informed them in writing that
Mhm.
you've revoked their position, but you've put a line through, stroke through, signed and had that witnessed. on the copies and tell everyone, bank, wherever you've
Like your bank, should you tell your bank?
yeah, absolutely. You can tell your bank, your insurance companies, your family and friends, everyone that knows about it, or you've provided a copy of the document. You should be telling them that that one has been revoked, and you will make a new one if you wish to supersede that one.
Yeah, yeah. Thank you. That's really good advice. Now, the banks are making quite a bit of progress in this area and have all sorts of ways of detecting financial abuse, looking very closely at transaction patterns and such. So, always helpful to notify your bank as well. Now, we've got a question here from Yvonne. Shawnee, are you aware of any specialized assistance for people with ADHD, or possibly other um, disabilities who may need additional care throughout this process? Are there services available to people who, you know, might require additional assistance?
Yvonne, I'm not personally aware, but if you contacted the Office of the Public Advocate, I'm sure they would be able to advise you what measures can be put in place and what additional supports there are available. Because I know that, not everyone that makes an enduring power of attorney can understand the documents and follow through with the process without that support. So my advice would be to contact the Office of Public Advocate, explain what support you are looking for, and they would be able to advise you further how they can support or another organisation can. I don't know off the top of my head.
Okay, yeah, thank you. That's really helpful. Now, I will mention that on Compass, all of our articles, particularly in the Enduring Power of Attorney section, can be downloaded as PDFs. So you can take them away with you, sit down with somebody else and go through them, particularly if you are somebody's support and you know an older person who doesn't have access to the internet, or it doesn't have a lot of digital literacy. You can do that. Likewise, you can change the language on Compass into several different languages. And we also do have a nice additional tool which allows people to change the type on the website, the size of the type, if you have dyslexia or you're colorblind. So those tools are available as well. I wanted to ask you about some simple things now about being an attorney, because once you appoint someone and they accept that role, it doesn't come with any training. And so, what's the best advice do you have for attorneys to really learn about what they're taking on, what their responsibilities are, and how best, how they should act? I know some attorneys don't know that they can't mix money. They've got to keep receipts for things. They have to, there are things that they need to do. Is there a handbook available that you're aware of that might be useful for a newly appointed attorney?
Unfortunately, there's not. And I know when we've had discussions with government, we've suggested that there be training
Hmm.
available
Hmm.
and that information, because you don't know what you don't know. And people could be making decisions with what they think is their best interest, but they're not taking other things into consideration. So to my knowledge, there is no particular resources that people can be given of being, this is what an appointment will look like, because it is different for every single person.
Mm.
What I would say to that additionally is that always act on the will and preference and of the older person or the person that you're acting on behalf of. Really try to understand what they want, because if you're understanding that, then and you're always acting in an ethical manner, then you can't go too far wrong. But it certainly is a really important and powerful appointment. So, yeah, there should be some sort of formalized training,
Mm.
I believe, that people should have to go through before they will say yes or no, because some people might say yes and not really understand the terms of the responsibility.
Yeah, yeah. Thank you. That's really good advice. Yvonne, look, I think many of us who have capacity can find these legal documents difficult to read through. I think one of the things on Compass we've endeavoured to do is to make things as easy to understand as possible in plain English. So we do hope that they are a support to you. We do have a newly published article on how to be a good attorney. It's not a formal training guide, but it is a helpful, and there's also a video. And there's also a great video there and helpful short article on how to choose an attorney, what you should be looking at. Look, I sat down with my attorneys and made them read articles on Compass and watch videos, and for that to be a kind of way of starting up a conversation and getting them to ask questions. And I think it's really about communication often too, having a good talk about it. Particularly if you have a condition, talking about how that condition might change and evolve over time. But many of us, I mean, I'm approaching my 60s, and we do know that dementia and other forms of cognitive issues can happen. But it's not only that, is it? I mean, I could be involved in a car accident, or there are other things that can happen. So it's good to talk about those scenarios and
It,
just get everything out in the open.
it absolutely is. And I think people shy away from that because they don't want to think about being incapacitated. They don't want to think about dying. But things happen at all different stages. And I would urge people to think about making an enduring power of attorney, enduring power of guardianship at a much younger age. Some
Yeah.
people wait till they're older, and they might have left the decision to make one too late because they no longer have the ability to do so. Because, like you said, Brett, things can happen instantaneously to any of us at any time.
Yeah.
And if we do want that choice and control after we lose capacity about who makes our decisions, it's really good to think about, because none of us are
No.
immortal. We're
Yes.
all mortal. So it's an important conversation to have, but I know a lot of people shy away from that, thinking, am I tempting fate if I'm talking about my future
Yep.
and these really important documents? My answer to that would be no. You're safeguarding yourself. You're putting your wishes down on paper.
Now we've lost your audio, unfortunately. Um, oh, it's back now.
Right.
Yeah. Yeah, just dropped
Um,
out there for a little bit.
that's
Um,
fine.
I was going to mention, or that it's sometimes I think people are maybe under the misconception that your next of kin will automatically be able to make financial decisions for you. That's not true, is it?
Not from a legal standpoint, but there's a lot
No.
of people that that is the case, and that's how they continue throughout their life, and it works wonderfully well. But
Yeah.
if we're talking from a legal standpoint, no, they're not. They don't have the ability to do that. Next of kin
Yeah.
doesn't give someone the ability to make decisions, as in an enduring power of attorney or enduring power of guardian.
Yeah. So another reason to have one. Now we've whipped through our hour very, very quickly. Thank you for the great questions. Now, if anybody's got an additional question, I would suggest please put it forward now. We'll be sort of wrapping up our conversation soon. A link with today's recording will be sent out to you on Monday, and you'll be able to watch that again. And I also wanted to mention we've got more Q&As planned coming from Compass. One we will be doing on how to be a good attorney in the new year. So if you're interested in any of our events, which are all free, then please register for our newsletter, which you can do on our website, which comes out once a month. Also has great information on issues around enduring powers of attorney. Now, in our final few minutes, I was just going to ask you specifically about conflicts of interest and what they mean in the context of an enduring power of attorney, because there's something people should avoid, isn't it, when they're thinking about choosing an attorney, is making sure that there are no conflicts of interest. And what would be a typical conflict of interest?
One we hear of is that if someone is being gifted money from the person, that they have been, if they've been appointed as an enduring power of attorney, but the person that appointed them is also gifting them money, that
Yeah.
can be perceived as a conflict of interest. Those things, it would go back about making specific clauses and decisions within that document. They're the sorts of things that are really important to discuss and document if that's happening. So that would be one of the biggest conflicts of interest if you're willingly giving that money, but you're the enduring power of attorney too.
Yeah, yeah. So something also to think about because it's an unpaid role, um,
Yes.
and I guess if you are aware and comfortable with conflicts of interest, probably best to document it in the document, and make that very explicit. And so seeking legal advice on that is probably a nice way for that not to pop up as a potential issue going forward. Now, one last plug for You Decide Who Decides the guide, which is on the Compass website. It is a terrific guide, very practical, with lots of helpful tips, has a special section in there for Western Australia and is brand new, was only published a week ago. So a very helpful national resource. Now, this is my final question, which is about harmonization. I know we've had these questions in some of the other Q&As. Is there a move in Australia to have the laws and rules around enduring powers of attorney kind of standardized across the
There,
states and territories?
there has been lots of discussions around that. Yes, there has been. There's been lots of discussions about the benefits and the the pros and the cons of doing that. I think national standardisation does work, but obviously that would be a big piece of work considering every state and territory has different legislation. It might give better oversight. It might come with a national registry of who's been appointed, because currently, if you are personally appointing someone to be your attorney, there is no record of that person being appointed. There is if it happens to be appointed through the state administrative tribunal. So yeah, watch this space. I think that's for
Right.
further discussion going forward. But I believe that has been a hot topic over the last couple of years about how to standardise that, making
Yep.
it less confusing for people too and more streamlined.
Wonderful. Well, thank you so much, Shawnee. It's been a terrific conversation with lots of helpful advice. Really grateful for your time, expertise, and experience. Thank you all for joining us today and putting your questions forward. I've really enjoyed today's session, and I hope you have found it helpful. Now, Compass is a project of EAAA. Elder Abuse Action Australia, which is the peak body dealing with this abuse of older people in all its forms. They're a terrific organisation, and you can find them at eAAA.org.au if you are interested. Otherwise, I'm going to say goodbye. Thank you very much, Shawnee. Enjoy the rest of your afternoon,
Thank you
and
so much.
thank you again.